Thank you. To take us to the case law.
My Lord, yes, if I may. So D4, which is at page 111, if that helps with the structure. And my Lords, I was going to turn to in re S, and in our submission, S supports the proposition that section 41.4 limits related to an offence through section 41.5 and then through section 40, and the individual aspects of procedure, including investigation and proceedings. My Lords, we respectfully suggest that it supports the proposition that a common factual origin is not the same as a common procedural origin. And when looking at related to an offence, one is looking at how it is limited through those sections. It is not dealing with a parallel set of proceedings. Worth emphasising perhaps that parallel lines do not touch. Insofar as S is concerned, this was, as your Lordships know, the VAT carousel fraud, and Customs and Excise began a money laundering investigation.
Sorry, I do beg your pardon. Just excuse me.
If you could pause for a second, I think.
Just having trouble.
Thank you. We found RAS at 436, I think, electronic bundle 436.
My Lord, yes, I was going to invite your Lordship's attention to 445, if that helps.
445. Well, while we're waiting for Lord Kitchen's computer to be reconnected, we can go to 445.
I do apologise. Just give me a moment. Yeah. Normally we use that. That's the second one.
Thank you, my Lord.
Thank you. If you could just...
Yes, my Lords, page 445, and I was respectfully going to invite the Court to look at the first submission made by Mr Perry on behalf of the Crown, which begins at paragraph 35 and goes over the page to paragraph 40, where Lord Justice Scott Baker gave the conclusion of the Court in relation to that point. My Lords, the second main limb to Mr Perry's argument was that it was no coincidence that Parliament had made public funding available for restraint orders when the 2002 Act was passed. He cited the explanatory note to section 41, and one sees that set out at paragraph 41 on page 446. And then perhaps I could invite your Lordships to look at paragraph 47 on page 447. The Court also adopted Mr Perry's submission that section 252 of the Act was all of the piece with the construction of section 41(4). Insofar as section 252 was concerned, there was scope for an ex parte order and applications to vary or discharge, and there was public funding available to challenge interim review orders, which was the precursor regime which existed at that stage. My Lords, perhaps pertinently in that respect, paragraphs 45 and 46 on page 447. I was then AP and U Limited, 2008.
Just before we go there, Mr Perry's arguments were accepted in this case, and that was as far as he needed to go to get the result he wanted. So in relation to the first point that Mr Perry made, there is no implicit exclusion of the argument that is being advanced against you today. I suppose you'd say in relation to the second point, the reliance on the availability of legal aid isn't. It would be to some extent a pointer against. But this case isn't authority for saying that the argument that you're meeting is wrong. It's merely authority for the fact that the restraint order proceedings in relation to the restraint order are covered by the statutory phrase that we are debating.
My Lord, yes, and indeed, if one looks at the context, they, at the beginning of the judgment, broke down into three possible categories. If one looks at page 440, at paragraph 12, F to G of the report, you'll see that they broke down. It's helpful for present purposes to envisage three different categories of legal expenses. One, those relating to the offence under investigation. Two, those relating to some entirely separate matter, for example, the purchase of a house already in progress or divorce proceedings. And three, those relating to the restraint order. And so you have those three categories in play for the purposes of the discussion. So I agree with your lordship in that regard, but what one does have is the court starting off looking at section 41(4) and thinking that related to an offence was sufficiently narrow that it only related to the criminal proceedings, and then it was reluctantly drawn away from that because of the provision of legal aid for restraint proceedings and because of the availability of public funding for tainted gifts. Public funding for recipients of tainted gifts. And so in those circumstances, it had to relate to restraint proceedings as well. But of course, if one looks at it in terms of the statute, one goes back, we respectfully suggest, to section 41(4). And if one conducts the trawl through section 41(5) back to section 40 into the individual sections, in each case one is dealing with the confluence of procedure, meaning that one is dealing with legal expenses related to an offence rather than legal expenses parallel or for parallel proceedings unrelated to an offence but related to matters having a similar factual compass.
Yes, I mean, that is the submission that you're making rather than something that we take from this case.
Indeed.
Yes, but you're going to move on to AP. Yes.
I was going to move on to AP and U Limited, my lords. And the court noted in that case that restraint orders dealt with funds the prosecution could well believe could well be the proceeds of crime. And perhaps I can invite you to look at paragraph 20, which is on page 459, the bottom of the page. And the court identified there that clear social issue engaged where permission was sought to use monies to pay lawyers for the benefit of the defendant who's either suspected of being or has been found to be a criminal, and found that Parliament was entitled to take the view that funds which may have criminal origin should not be so used, but had to take into account the consequences, namely that other means would have to be provided to enable defendants to have legal representation during restraint and confiscation proceedings. And the course adopted was to provide state aid. My lords, perhaps I could invite you, please, to look at Article 1 of the first protocol, which is set out in S at page 448.
Well, just before we go there,
oh, yes.
the social issue identified in paragraph 20 clearly could cover civil proceedings of the sort that is being argued for against you. What you're relying on here, presumably, is the statement in the last two sentences that that other means had to be provided to enable the defendants to have legal representation during restraint and confiscation proceedings. And that was state aid. Now, I think your case is that there will be civil proceedings, such as judicial review, relating procedurally, as it were, to restraint and confiscation proceedings that will be covered by Section 41(4). Is that right?
Yes.
Yes. Based on the case law.
The prohibition would apply.
Yes. Yes. But and there isn't automatically state aid for that, for those proceedings.
For judicial review, it is in, if it's related to criminal proceedings, it is available.
It is available as a matter of
I wouldn't say as a matter of course, but it's certainly readily available.
It's readily available.
Circumstances where one frequently has appeals in the administrative court by way of judicial review, and indeed cases stated from the magistrate's court where recourse to public funding is such that it is readily available.
Yes.
My Lord, you've identified the key aspect of the submission, which is why I'd respectfully invite you to look, please, at 448, which is where, in the body of the judgment in S, one has set out Article 1 of the first protocol, which is at H of the report. My Lord, going back to my Lord Lord Hodge's point about public funding, in AP's case, the court was able to take it as read that state aid would be available.
How is A1P1 engaged here?
My Lord, on the basis that it is the funds of the defendant.
They're being restricted. Their use is being restricted. Is there a deprivation of funds?
Is there
a deprivation of funds?
No, this is a control. So it's part two. It's part two of A1P1. So the preceding provision shall not, however, in any way impair the right of the state to enforce such laws as it deems necessary to control. So I was coming to that. It's in two parts.
Yes.
And paragraph, I've invited you to look there because it sets out A1P1. Mm-hmm. If one then goes to 460 and looks at paragraph 22, please, of the judgment in AP. The court found there that the fact there may be hard cases as a result of a measure doesn't mean that the measure is incompatible with convention rights. Our submission is that in a case such as the present case, every case is going to be a hard case because the requirement for exceptional case funding means that legal aid really is illusory. My Lords, that may give rise to Article 6 considerations in individual cases, as is clear both from paragraphs 21 and indeed 24 on pages 460 and 461. And in AP's case, the court concluded in relation to AP that Parliament was entitled to make the choice it did. In the context of restraint orders, funds couldn't be drawn from restrained funds. However, the defendant would have to rely on state aid instead. And it was the particular quirk of AP that state funding at that time, with a change in representation, was sufficiently low that no advocate would take on the brief. But that was described as a hard case.
So do we know whether AP got legal aid to bring these proceedings?
In AP, the case was stayed by His Honour Judge Mole.
In order to bring the case to the Court of Appeal, did AP get legal aid?
Oh, for the purposes of the Court of Appeal, my inference has always been that he was able to be paid through the registrar on a separate legal aid order, as opposed to the legal aid that applied in the Crown Court at Harrow, which derived from the graduated fee scheme. So that is why he was represented in the Court of Appeal. But in the Crown Court, he was unrepresented because of the level of fees available. And my recollection is that that case was stayed. Lords, I can deal with the two Anderson cases in short order.
Just before you go on, I'm not sure what I'm getting, what your submission is in relation to AP Protocol 1. I mean, I think your opponent said, well, if there are human rights issues, they will be dealt with in any event, for example, by staying, but that is actually a separate, as I understood his submissions, a separate issue than the one we're here dealing with. Are you contradicting that? Or
we respectfully suggest that if one looks at this through the lens of Article 6, then it can be dealt with on a case-by-case basis, because one looks at unfairness in its strict sense at the point at which it arises. But where one is dealing with an Article 1 First Protocol issue, as here, the situation is different, because there has to be provision, as was noted in the judgment, for state funding. Otherwise, there is a violation from the inception of the lack of availability of funds.
Why is
There's a failure to comply with Article 1 of the First Protocol.
I don't quite follow that at the moment.
I'm struggling with that point as well.
Yeah. The second part of A1P1 is limited, is a proportionality test, and it's not engaged at all under Ellen Kane if the European is not a matter of the proportionality assessment being carried out by our Parliament or by the courts. It is the proportionality assessment which is carried out by the European Court of Human Rights, allowing a margin of appreciation.
My Lords, could I invite you to the extract of the judgment of Lord Justice Latham at paragraph 19 in that regard, and the last 8 lines of that paragraph.
Which page number?
Forgive me, page 459, and I can read it, is that the fact that there may be harsh results in some cases does not justify the conclusion that the measure is incompatible with Article 1 of the First Protocol. That could only be so if there was such a significant population of those unable to obtain representation that there would be a clear systemic failure to provide the alternative which Parliament had considered appropriate. In our respectful submission, we are in that territory here, and they were not in that territory in that case.
Again, I struggle to see what the judge is saying here, because what is the incompatibility with A1P1? The property is being controlled. It's not the defendant isn't being deprived of it, and A1P1 in terms says that it doesn't apply to the control of property. So where's the deprivation?
It's not a deprivation point, it is a control point. But we respectfully suggest that there have to be other means provided in the context of the deprivation limb of Article 1 of the First Protocol.
And why is that? Because the Article 1 enables the state to control the use of property. It doesn't have a counterbalancing or countervailing. You then have to provide free legal aid, especially in the context where Article 6 doesn't require there to be legal aid for
it's not
proceedings.
It's not Article 6 we rely on.
I appreciate that, but the Article 6 and A1P1 surely should be read together.
My Lords, we respectfully suggest that when one looks at that second limb, the preceding provision shall not, however, in any way impair the right of a state to enforce laws as it deems necessary to control the use of property in accordance with the general interest or to secure the payment of tax or other contribution penalties. We suggest that that is engaged. And when one looks at general interest in the context of the court seeing fit in the context of restraint and criminal proceedings to grant legal aid, then Article 1 First Protocol is engaged, and the course adopted should be to provide state aid, and that isn't available. It relates to the general interest, we respectfully suggest.
So the submission, as I understand it, is that if we were to find against you, this legislation would be in contravention of Article 1, Protocol 1, because, as I understand your submission, it is necessary to allow the release of the property in order for people to defend civil proceedings.
My Lord, yes, we were looking at it for the purposes of construction from the other end of the telescope, which is that if Parliament had intended the meaning which the appellant suggests the court should adopt, then funding would have been provided, as it was in relation to both criminal proceedings and proceedings relating to the offence in the guise of restraint proceedings.
Is the general interest determined by the European Court of Human Rights, or the legislator, or the court?
Well, my Lords, ultimately it would be assessed by the European Court of Human Rights, but in the context of Parliament's clear intention, one can derive from the position vis-à-vis criminal legal aid that Parliament's intention was that state aid should be provided.
Yes.
Are you making the case that the appellant's interpretation of Section 41, subsection 4, is incompatible with A1P1?
Well, my Lord, I suggest I'm bound to answer that question in the affirmative, as I have in response to my Lord Burroughs' question of me. But as I respectfully suggest, we have approached it from the other perspective.
There's no notice of incompatibility?
No.
The argument wasn't raised in the courts below?
My Lord, that's right. And we hadn't approached it. We hadn't approached it through that lens.
We may not be in the realms of a declaration of incompatibility in any event, because the essence of your case is that you can construe the provision in a way that is compatible with the convention.
Well, my Lord, yes.
Yes. But at the moment, I have to say I struggle to see that A1P1 has anything to do with this at all. But I have your submission on that point.
Yes, thank you, my Lord. My Lord, the appellant relies on the two FSA and Anderson cases. They can be dealt with in short order, we respectfully suggest. Mr. Justice Briggs expressly said that it was not for me to express any view of my own as to that interpretation of Section 41(4)(a) on the facts of this case, and the reference for that is paragraph 36 of page 401. Insofar as Mr. Justice Voss' judgment is concerned, his lordship merely recorded that Mr. Purchase's submissions, which had been made on behalf of the FSA without any engagement from the unrepresented defendants in the case, recorded that his submissions concluded that there appeared to be a sufficient basis for the conclusion that the facts of these proceedings were sufficiently closely related to the offences being investigated to mean the Crown Court had no jurisdiction to make an exception, so as to allow the defendants to use the assets covered by the restraint order to pay for their legal expenses of defending this action. That's at paragraph 24, page 408. It's simply a record of a submission, and so there was no discussion or finding. My Lords, insofar as our D5 is concerned, the contrast with Section 245C, could I invite you please to look at the Court of Appeal judgment, which is at page 146. Dealing with the fifth aspect of Lord Justice Popplewell's findings. Go over the page 252. And you have at paragraph 52 the court's findings.
Somewhat different from Section 41, subsection 4, insofar as the legislative steer is still that in relation to restraint proceedings, the money is to come from public funds by way of legal aid.
My Lords, yes, but we would respectfully adopt the final sentence of paragraph 52, and when one interprets section 41, taking into account the statute as a whole, including part 5, we suggest that on the basis that it is permissible for civil recovery proceedings to be funded at a defendant's own expense, it must be a fortiori the case in relation to independent civil proceedings. And the court could have drawn further support, we respectfully suggest, for the amendments to section 41 to introduce subsections 2A and 2B, where the relevant legal aid payments are criminal only. My Lords, could I turn then to our submissions in relation to discretion, which is at our page 114 of our case. And we deal first of all with steered discretion. I've addressed your Lordships generally in relation to this, but we would respectfully invite the court to bear in mind, in the context of how the steered discretion would be exercised, how the Court of Appeal dealt with reasonableness in the context of living expenses, in particular at paragraph 33 of the judgment, in the context of the court rejecting the notion of a defendant being allowed to maintain his lifestyle pre-trial in the way that defendants have been able to historically. And so the rejection of concepts such as Rolls-Royce lifestyle being appropriate. Important themes, together with paragraph 33 itself. And those are non-exhaustive factors which can be applied and would be applied to legal expenses, mutatis mutandis. But importantly, at paragraph 33.7 on page 141, there's the introduction of the notion of searching for a cap, whereby there would be a level which is inconsistent with the statutory objective of preserving assets so far as possible for the purposes of enforcement of confiscation order. And we suggest that those factors are significant means of controlling the quantum of funds released for reasonable legal expenses. My Lords, in terms of practicalities of steered discretion, the appellant's submissions are that it will be a difficult exercise for circuit judges in the Crown's Court. The appellant's submissions, we suggest, overlook the fact that many circuit judges sit both in civil and family and criminal jurisdictions, and of course many circuit judges are Section 9 judges in any event. There's always the possibility of enabling a High Court judge to deal with a particularly complex application as set out in the case of Windsor by Lord Justice Hooper. Can we turn then to statutory interpretation, which is at page 116, please?
In one sense, everything we've been discussing is statutory interpretation.
Well, my lord, that's right. And with that in mind, could I respectfully invite you to look at F3, which is interpreting the Proceeds of Crime Act. By reference, we suggest initially to Ahmad and Fields. And we'd respectfully suggest that the appellant's submissions seem to impose an absolutist or an almost absolutist position on the statutory steer. And one cannot derive that from the statute or indeed from the authorities. Could I ask you please to look at Ahmad and Fields briefly, which is at page 801. And at the top of the page, paragraph 38. My lords, we respectfully suggest that contextualise is the approach to statutory interpretation in the context of the Proceeds of Crime Act, in particular, how the approach is tempered by Section 69. Beyond that, perhaps I could invite you to look at page 660, which is within the case of In re Peters, which was 1988 case under the antecedent regime. And at page 660, one has the submissions of Mr. John Laws as he was before Lord Donaldson. Could I invite you to look at the approach set out there, please, from C to H? We respectfully suggest that when one looks at the statutory steer, albeit it is different in a nuanced way under Section 69, it is not as hard-edged as the appellant suggests. My lords, then F4 explanatory notes. Perhaps I could ask you to have a look at page 1124. we respectfully suggest that tends to support the limited construction on section 41.4 that we suggest should be derived from its natural reading. My Lords, then, insofar as F5 is concerned...
Just before we go there, these explanatory notes, are they departmental explanatory notes or are they produced under the aegis of Parliament? Do you know?
These, I'll be corrected if I'm wrong, these are produced under the aegis of Parliament.
Departmental. Sorry, I hesitate to interrupt. The Home Office takes custody of proceeds of crime legislation, and internally Home Office lawyers produce explanatory notes.
Yes.
My Lords, in terms of the mischief Parliament sought to cure, could I invite you to look at 1153, please?
I hope you don't mind me asking, just to make sure that I understand it correctly. Legal aid for criminal proceedings, for the actual offence itself, are they subject to different rules than would apply in relation to legal aid for judicial review of those proceedings? They do. So there are different criteria that are applicable.
Yes.
So legal aid for the actual offence itself is far more readily available.
Insofar as judicial review is concerned, it is less available, but it is readily available, as opposed to the situation that we are in a case like this, dealing with chancery proceedings.
I would be very grateful for some references to the legal aid provisions that govern the respective types of proceedings.
My Lord, yes. Perhaps I can deal with this component of our submissions and then turn to legal aid. So far as our section F5 is concerned, one has at 1142 the Performance and Innovation Unit report of June 2000, where the mischief was identified, and this was referred to by the Court of Appeal in S. But perhaps I can take your Lordships to page 1153. In fact, could I give you some references rather than inviting you to read everything at this stage? 836, which is on 1151, and 837, then 846, which perhaps I could invite you to read, which is on 1153. My Lords, 847. Then one sees at 848 the proposal being based on civil restraint provisions in New South Wales, where rates up to 20% above legal aid are permitted. And that was a conclusion at 29 on 1154. The level of those fees is perhaps indicative that it was to be confined to criminal and restraint proceedings, but the costs that had given rise to the mischief are described in the table 8.2 at page 1151. And your lordships will see there they relate to defence costs and receivers' costs. So that was the issue Parliament was seeking to cure, namely the overspending in the conduct of privately funded criminal defence work, including restraint and receivership.
So there's no mention in any of this report about the problem we face today about civil proceedings?
No. The point is the mischief that had been identified was that those who would ordinarily have their assets taken from them in confiscation were spending what was perceived to be a disproportionately high amount on defence, on private defence fees in the criminal proceedings, including receivership and restraint proceedings. And it was for that reason that Section 41 was drafted as it was.
Yes, 836, which I don't. Yes, which you did refer us to, but you said you wouldn't look at. But there, your point, I think, is being made that they can also dissipate restrained assets to pay their legal fees in defending the criminal case, sometimes at very high rates. Yes. You say that was the mischief that this document was addressing.
Yes, and my lord, we respectfully suggest that that's underscored by the contents of the table. Yes. On page 1151.
Yes, thank you.
Lords, insofar as F7 is concerned, that's our section on pepper and heart. If the court were against our submission that section 41.4 is not ambiguous, then we would rely on the extract from Hansard set out at page 119, which is that of Lord Rooker. Lords, our next section is F8, which is unjust result, oblique consequential reasoning. And we don't propose to elaborate what is set out in writing. We simply say this, that the Court of Appeal Criminal Division was not concluding that the appellant's construction, as suggested, was wrong because there was an unjust result. There was an observation that it was wrong, in particular by reference to the de minimis characterisation, and it was pointed out, juxtaposed with that in paragraph 46, that it would lead to an unjust result, but that wasn't part of the reasoning. And my lords, turning to legal aid, in criminal proceedings, defendants are eligible for legal aid irrespective of means, subject to the qualification that a contribution may be payable, subject to the prohibition on the immediate payment of that, pursuant to the amended section 41. Insofar as civil legal services are concerned, they are governed by section 9 in relation to general cases. They are described in Part 1 of Schedule 1 to the 2012 Act. And the Director of Legal Aid Casework has determined that individual qualifies for services as a second limb to the availability. Then in Part 1 of Schedule 1 to the Act, there is a list of 46 types of case where they are described as general cases where somebody may be eligible for public funding. They include such matters as care, supervision, protection of children, special educational needs, child abuse, vulnerable adults.
Sorry, which page are we on?
My Lords, I was in fact answering my Lord Stevens'
Yes, I realise that.
question.
Maybe it's not in the bundle. Don't worry if it's not. I thought you were reading from the bundle.
My Lord, no, I was reading from a synopsis of the provisions. Perhaps I can...
So what's the Act again? Sorry.
There's NAPSO.
Yeah.
NASPO.
Yes. And my Lords, within the general cases is judicial review, so that is within scope. My Lords, I've been reminded as to why the references are not here. It's come out in a strange way at tab 30. Perhaps we can ensure that you're furnished with this
Thank you.
this afternoon. But the general cases include judicial review, which is why that is a type of case to which somebody is eligible, because it is in scope. Absent from the list are, for example, civil fraud, tort, breach of trust, professional negligence, and the like. Part 2, Schedule 1, lists services specifically excluded from general cases, and they include claims of negligence, which is one of the causes of action in the civil proceedings here, and matters of trust law. So in those circumstances, the respondent's claim is not covered by general cases, and at least in part excluded by Part 2, Schedule 1. So then one has to look at exceptional cases, and civil legal services are only available where subsections 2 or 4 to section 10 are met, and they relate to, insofar as subsection 4 is concerned, inquests, and where the director in relation to subsection 2 has made an exceptional case determination and not withdrawn it. And so you have the need for there to be an exceptional case determination, which is then further defined in subsection 3, and where it is necessary to make services available to the individual under this part, because a failure to do so would be a breach of 1, the individual's convention rights, 2, any rights that are enforceable EU rights, or B, that it's appropriate to do so in the particular circumstance of the case, having regard to any risk that a failure to do so would be such a breach. And then insofar as those determinations are concerned, one looks at section 11, where the director has to consider by section 21 financial resources and criteria set out in a regulation produced pursuant to that paragraph. And financial resources are dealt with pursuant to the Civil Legal Aid brackets financial resources and payments for services brackets regulations 2013. So a person under an all assets restraining order would be financially eligible. The threshold under regulation 7 there is £2,657 gross monthly income. You then move to Civil Legal Aid merits criteria regulations 2013, and pursuant to regulation 11, the director must apply general merits criteria and must apply a merits criteria which are appropriate in the case. And the individual may only qualify for civil legal services if the director is satisfied that general and to extent relevant specific merits criteria are met, a reasonableness test is met under two sub-paragraphs. And then, my Lord, it descends into detail of individual types of legal services depending on the stage of proceedings or whether it's before proceedings have begun, including help at court and legal representation. But significantly, the merits test will apply, taking a slightly higher level look at it. And in those circumstances, it means we respectfully suggest that in practical terms, as identified in the FSA case by Mr Justice Briggs, as he was, in practical terms, one will not be eligible for legal aid, assuming a lawyer is willing to go through this exercise to this point. My Lords, perhaps in light of my Lord Stephen's question, we can supply the relevant extracts of the statute and the regulations.
Is there any dispute in this case that as regards the civil proceedings, legal aid is not available? I mean, is this common ground between the parties?
Well, as far as we know, no application has been made for civil legal aid, but as we understand it, and that's why we made the submissions in the way in which we did, and whilst it's out of scope, Section 10 applies if it could come within exceptional case funding, because there is a breach of Article 6, or would otherwise be a breach of Article 6, then in principle, legal aid would be available.
Thank you.
But we don't know whether any application has been made, or if it has, what the result of it was.
Well, and it being out of scope, exceptional case funding is required, and therefore the merits would have to be looked at in circumstances where that may preclude the grant of legal aid in reality. So it is an illusory, we respectfully suggest.
It isn't equally illusory if you're making an application to a judge to exercise his discretion and there aren't any merits.
Well, my Lord, in that regard, we respectfully suggest that in a case, in this particular case, it wasn't illusory to ask for a limited quantum of funds to be released from the restrained funds in order to try to negotiate a settlement or to set the negotiations on the right path where one was dealing with this multi-party litigation.
Well, then wouldn't you meet the merits test? If the merits test was this is a very good case for us paying up the money or agreeing to the settlement.
it may be eligible for that specific purpose and only that specific purpose.
Yes.
Yes. My Lords,
Have you applied for Section 10?
my Lords, as I understand it, Mr Luckhurst has been placed in a position, and your Lordships, I hope, will have seen the witness statement of Mr Henry, together with the annexure, which is the letter from the civil solicitors. As I understand it, because of the position he is in at the moment, there is no assistance being offered to him from those solicitors. And those instructing me are instructed only in relation to the criminal proceedings. My Lord, could I invite you to look at 1107, which is the application for exceptional case funding? And in bold, immediately above the box on the first page, the overarching question is set out. And that of itself, we suggest, presents an impediment.
Sorry, which page?
Page 1107, my Lord.
1107?
Yes.
Thank you.
My Lords, that takes us to what we say by way of conclusion, which is it may be that one need not look beyond the interplay between sections 41, section 40, and the sections referred to within section 40 and its subsections, because that limits the definition of offence and limits the scope of section 41(4) in a clear way pursuant to statute, and in those circumstances we respectfully suggest that the Court of Appeal was correct to conclude in the way it did vis-à-vis the legal expenses in this case. I don't know if I can assist your Lordship beyond that.
Thank you very much, Mr Douglas-Jones. Mr Talbot.
Five short points in reply. The first is in respect of the test for expenses which relate to an offence, which in all senses is the issue in the appeal. My learned friend was asked to articulate the test and gave the court a number of formulations. I'm not going to repeat them, but our answer is, we submit, simple. We say that offences are comprised of facts, and the facts will always be the commission, or perhaps occasionally the omission, of activity which comprises the actus reus of the offence, accompanied usually, but not always, by a particular state of mind. And that's all wrapped up in a legal framework. And those are issues of facts and law, or mixed facts and law. And it's very easy to formulate the test in the way in which we do, which is the only way one can formulate the test, that any civil proceedings which concern those facts which are wrapped up in that legal framework are civil proceedings if expenses are sought in respect of them, expenses which relate to the offence. That's the way we put it. And one can see that articulated in our written case, paragraph 17 to 18, page 74. The second of 5 points. Section 41.3, and my Lord Burroughs' observation plainly right. There are some circumstances in which a Crown Court judge has to conduct the exercise of deciding whether legal expenses ought to be released, because it's not a case where there is an overlap or otherwise the civil proceedings relate to the criminal investigation or criminal prosecution. And we accept, of course we do, that is the case under section 41.3. But what we submit is that there are limits to the circumstances in which that arises, and one gets that quite easily from a short journey through the statutory provisions and their history. The Criminal Justice Act 1988, which allowed access to legal expenses on a discretionary basis in all cases. See our written case, paragraph 35.2 at page 81, followed by the PIU report to which my learned friend took the court, which plainly evidences as an external aid to construction the particular mischief which the legislature had in mind to keep cases where large amounts of funds were spent on legal expenses down to a minimum. And again, we cross-refer to the PIU report, paragraph 36 of our case at page 82. And what we submit that whilst it's right that there are circumstances in which the kind of exercise postulated by my Lord Burroughs does have to be undertaken, it's clearly parliamentary intent that they should be kept to an absolute minimum. That's the second of 5 points. The third of 5 points is in relation to changes to Part 5, permitting the release of funds to meet legal expenses, and how that relates to the construction of Part 2, the restraint order provisions. And my learned friend referred to Section 245C, which is the statutory provision whereby Parliament widened the type of restraint powers to include not only interim receivers but property freezing orders to prohibit those who were being pursued for civil recovery from dealing with their assets, but at the same time allowed those assets to be accessed for the payment of legal funds. Section 252.4 was substituted with terms in similar respect. Well, we've already made our submissions that in general one cannot deploy the amendments to some sections of an act to construe other sections which weren't subject to a similar amendment. Made those submissions when opening the appeal. But even if one looked at it more broadly and decided that one would look at these amendments to see what light they throw on Section 41.4, what in fact happened under the regime as amended by the 2005 Serious Organised Crime and Police Act, which substituted these new sections in Part 5 in relation to civil recovery, was that the High Court was given a discretion. It's High Court, of course, which tries civil recovery proceedings. High Court were given a discretion, but subject to very strict statutory stabilisers. First, under the primary legislation, any exclusion for legal expenses must specify a particular amount. And secondly, any exclusion must comply with the conditions which are specified by the subordinate legislation. And one sees that in section 245C, for example, page 375 of the bundle, where one sees those statutory requirements for an exclusion. Then the relevant regulations, which are at page 1041 of the bundle, which set out the conditions which must be satisfied in order to justify a release, are detailed. They require a stage plan. They require a specified amount, as the primary legislation does. They require, once an exception of an amount has been agreed in principle, a further application for sums to actually be released. If there's a dispute between the defendant and the claimant bringing the civil recovery proceedings, then the right to draw on the frozen funds is restricted to 65%, with the whole of the sum claimed, with the whole amount then set up for an inter partes assessment by a cost judge. There are caps on hourly rates. They're all specified in the statutory instrument, and your lordships can look at that from page 1041. So what we say is that Parliament, having enacted that strict regime with those, as I've put it, statutory stabilisers to control quantum, it cannot be inferred, or neither can, more particularly, those changes which were brought about by SOTBA be used to support a construction that Section 41.4 permits the same kind of expenditure, or expenditure of the same, in respect to the same type of issues, to be subject simply to some kind of judicial discretion without any control at all, any statutory or parliamentary or subordinate legislation control at all. That's the third of 5 points. The fourth, my learned friend seemed to suggest that the precise identification of categories of case where legal aid is available determines the scope of Section 41.4. And he relied on AP and U for that proposition. Our answer to that is that an interpretation where the scope of the prohibition is determined by the applicability or scope of legal aid, it's highly uncertain. It could, and in fact in this case and in these cases under POCA and LASPO, change over time, and that's highly unlikely to have been intended. What we say is one has to look at the Act in the first place, and one finds, when looking at the external material, that there is support for the proposition that legal aid ought to be available to ensure that particular types of case are covered. And we've made our submissions on why in civil proceedings that stops at the point of exceptional case funding for the purposes of avoiding a breach of Article 6. But beyond that, one cannot use the availability of legal aid as a mechanism to interpret Section 41.4.
Yes, well, the legal aid regime that was available in 2002 when POCA was enacted, this is well pre-LASPO and so on, would be very different from the legal aid provision available post-LASPO. And presumably the meaning of Section 41.4 didn't change when the legal aid regime changed.
Precisely, my lord, yes.
Yeah.
Of course, yes, your lordship's absolutely right. It was the Access to Justice Act 1999, and we all know that LASPO is intended to cut back rigorously the scope of legal aid available in civil litigation. Mm-hmm. The last of 5 points is on A1, and as I understand it, my learned friend advanced the proposition that A1, P1, Article 1, Protocol 1, the right to property, deserve some kind of independent further consideration from Article 6. And we wouldn't accept that proposition, and it would appear to us respectfully that in observations from the court understands the point that I'm going to make. A1P1 is a qualified right. This court is very familiar with the operation of qualified rights under the Convention, and in particular qualified by reference to control of use, because one isn't concerned with deprivation, but with whether the defendant's otherwise unfettered access to his own money should be controlled. And as with any qualified right, the issue comes down to, is there a lawful basis to restrict the use of the assets which are frozen? The answer is yes. Section 41(4) on our submission provides it. Secondly, is the control of use, the restriction on those use of those assets in pursuit of a legitimate aim? And plainly it is. The confiscation of the proceeds of crime and the compensation of victims. And of course the proportionality test. Is there a reasonable relationship of proportionality between the means employed, namely Section 41(4), and the pursuit of the legitimate aim? And of course the obvious point is that the only circumstances in which one could say it is disproportionate is if the restriction on the use of the funds to pay for lawyers impacted on the defendant's ability to conduct the civil litigation in a manner which allowed him effective access to the court or otherwise would create obvious unfairness. So in fact that's why the A1P1 argument folds back on itself and into Article 6. There's nothing in the A1P1 point. I don't know if I can assist the court any further.
Mr. Talbot, thank you very much. Well, the court is very grateful to counsel for their oral submissions, and also to those who assisted counsel in preparing those submissions and preparing the documents which we have considered and will consider in this appeal. The court will now take time to consider what is the correct outcome of this interesting problem. Thank you very much. We'll now adjourn.